All right, so let's delve in and examine all those actions, inactions, reactions concerning the Supreme Court's ruling concerning the Imo governorship appeal. Let's start from Abuja. Markwe?
Right now, we have with us Mr. Victor Giwa, who is a legal practitioner. You're welcome to Sunrise Daily.
Yeah, thanks so much for having me. Good morning.
Good morning. What do you make of this, of the judgment and the reactions that have followed it so far?
Well, thank you very much. I think, first of all, that is the judgment of the Apex Court, the Federal Court.
A unanimous judgment?
Yes, unanimous judgment, yeah.
Of the Apex
Court, yeah. And one of the things that the populace expect to get from the Apex Court is, one, to get justice, two, to disrupt certain status quo, especially when that is being exploited, when that particular status quo is being exploited by certain persons. And I will give you the details. Election in Nigeria has been taken over by some desperate politicians. And of course, the issue of election has to do with protection of our democratic process, the right of the people to choose who is to govern them. And in this particular climate, we have seen desperate politicians who will stop at nothing to ensure that they get into power. Of course, not to serve the people, but to, to amass wealth for themselves. And so for that reason, we have seen a lot of, permutations politically, and now it has even entered into the judiciary. And let me give you an example. The case of Amechi versus INEC, that the Supreme Court decided, where Amechi was declared to be the winner of that election, started with this same Imo State. And at that point, the then PDP had a candidate called Ifeanyi Aragome, and of course, that was the process where you have issue of substitution of candidates. At a point, Aragome emerged as the candidate for the PDP, and the then persons in power, within the then PDP, were not comfortable with the fact that Aragome emerged. And when the Court of Appeal, it was a pre-election matter, he got to the Court of Appeal, and the Court of Appeal said, no, you wrongfully substituted this person. The right person to have been declared the candidate is Ifeanyi Aragome, until he went to the Supreme Court. And the Supreme Court took the same position. But guess what the PDP did at that point? They now said that, look, against the decision of the court, that they don't have a candidate, that they are not ready to contest the election. And so, of course, as a political party who has the right, whether or not to, they said, so they now nullify and put into non-effect the decision of the Supreme Court. So when the same occasion came up in Rivers State, the Supreme Court said, no, when we take a similar decision, the PDP would also follow that same pattern and made the judgment of the court of non-effect. And they said, no, we are going to invoke our power. And they now set the first precedent. And I'm coming from this process for you to see what is the effect of the Supreme Court decisions. So it is not just to give justice, but to disrupt certain things which the politicians have been able to exploit using the law. Now, let me come back to this judgment. First of all, let me put certain facts in place. One, the government of the issue is that, one, the election was conducted on the 9th of March 2019, and they had about 68 candidates outside the other 4 candidates that were in the election, in the election tribunal. Ihejoa was declared winner, and Uzodinma went to court, filed his petition on the 30th of March. Now, what was his issue? Which a lot of persons have not understood. The first issue was that, one, he claimed that Ihejoa did not win the majority of the lawful vote, and two, that there were 388 units where he won majority of the votes, and that those votes were excluded from his votes. And so his issue was therefore that there was an unlawful exclusion of his votes, and that 388 units has 213,695 votes from the 388 units, which, according to him, were not included. His votes were not included in his vote. Of course, he got 96,000 as declared by INEC. Election was conducted in 325 polling units in Imo State. And the results of the election were announced in 288 units, while 252 units were cancelled. The question therefore arises, and that is, how would you establish, especially when INEC, the agency that has, of course, the responsibility of conducting of elections, said in their reply that, look, the result you are talking about, the 366 units and the 213,695 votes, did not come from us. Because INEC position, if you look at the record of appeals in volume 4, page 2956, they said the result being alleged by Uzodimma is false. The question is, what position should the court take within this circumstance? Now, here are the issues. A judgment is a collection of principles, precedents set up by the courts. Mm-hmm. And the first part is that it's the tribunal that has the opportunity of listening to the witnesses, hearing the evidence, looking at the body language of the various witnesses, having a first-hand information of the document, interrogating the document when it is necessary, asking questions from those witnesses directly. And that will be at the tribunal.
And the tribunal set them aside.
And the tribunal set them aside.
Yeah.
The APC candidate, Uzodimma, called about 58 witnesses. 28 of them were polling agents. The candidate himself was witness 11. His coalition officer was witness 51. And then there was this police officer, DCP Rabiu Husseini, who was witness 54. And who was the person who brought in the result? Now, yes, this is the question. The contestation in that election was that there was a 388 units where the results were not added to his vote. My first question is this. During the giving of the evidence of the witness of DCP Rabiu, who was then the director of operation of the Nigerian Police Force Imo State, who was at that time now in Makurdi, he came and has been subpoenaed into the court. Mm-hmm. Instead of presenting, because the issue in contention was 388 units, mm-hmm. he said he could only have 368 units of that result, and that he could not lay his hands on the remaining results of 20 units, which is EC8A sheet. So
the point you're making is?
Now, where did they get, because that was the person that brought the result, mm-hmm. where did they get that 233,695 votes that Uzodimma claimed was gotten from 388 units, while the petitioner presented 368 units?
Mm. So those are critical questions. I mean, the scenario you have painted right now for a lot of analysts raises questions about the role of INEC, who actually has the power to authenticate results. They say these are the consequences that have emanated from the Supreme Court judgment. You have talked about the Supreme Court seeking to disrupt certain things that happen, and you can speak to the disruption in this scenario much later. But let's quickly flip now to Lagos. I believe we have a guest in London, Chamberlain.
Yes, indeed, Mark. Well, we've got Mr. Adebayo Ojo, who is the former Attorney General for Oyo State. He joins us via Skype from London. Good morning, and thank you for joining us today. You've heard the views of your legal colleague talking about the questions to be determined. What do you think, first of all, of that judgment and the several reactions coming through about it?
Good morning, Nigeria. First and foremost, I want to align with my colleague who just spoke, your guest there. Is a thoroughbred practitioner. and he knows his onion and is not being political. He's talking like a lawyer on your program this morning. Yes, having said that, you see, we must tread carefully and cautiously and not try to desecrate our institution, in particular, the Supreme Court. We must appreciate the enormous and equivalent tasks and jobs before the Supreme Court arising from the last general election which we had. You see, most commentators who have made critiques or who have critiqued that judgment of Usodima and Eodia, most of them, I'm able to say, they've neither seen nor read the judgment. Some of them don't even know who the parties are. They don't know the issues in context, and they don't know anything about the case in question. So they are just being emotional or sentimental or being used politically. Having said that, let me now say that the issue in context in that case, the gravamen or the cross of the new governor of Imo State, who was declared by the Supreme Court to be the governor, Usodima, in that case, was that during the election, 380 results from 380 units that were in his favor were excluded, were not used by INEC. That was his pleading. INEC did not counter that, did not controvert that piece of pleading. And evidence were led on that. And in proof of that, is cancelled.
Mr. Joe, if I could just jump in and say this. I'm not sure what you mean by when you say INEC did not contradict that, because at the tribunal and at the appeal stage, INEC gave reasons. I mean, they still rejected that results, those results, rather.
Pleadings were filed at the first at the lower tribunal, at the first tribunal. Pleadings, nobody filed pleadings at the Court of Appeal or the Supreme Court. No. You fight pleadings.
Yeah, did INEC accept it at the tribunal and at the appeal stage?
You see, when the other party pleaded some facts, you have to beat it frontally. You have to controvert it frontally, and not by being evasive.
Mr. Just give us a direct answer. From your perspective, did INEC admit those results at the tribunal and at the appeal stage? I'm not sure what your views are on that.
The INEC did not deny that pleading. In essence, they admitted it.
Admitted facts the results, or that, yes?
Denied. In law, fact not denied, are deemed admitted. They are deemed admitted. It's like if I said, Chamberlain at this time is in TBS Lagos, and you didn't see anything. But if you want to deny it, you say, as at this time, I'm on Channels TV Sunrise Daily. I'm calling the program. You've met my pleading frontally.
Yeah, but they didn't admit the results, did they?
They admitted the result. They are deemed admitted because they've not been denied expressly.
Because from the findings there, the big questions were that INEC did not accept those results that came from the APC candidate, because they say there were non-use of smart card readers, there were irregularities, and that's why those results were not admitted in the first instance.
Let me explain to you. In proof of that pleadings, Usodima, the governor now, subpoenaed PW11, DCP Rabiu, as correctly stated by my learned friend, your guest. DCP Rabiu was then a police officer in Imo State, but during the trial, he had been posted out by the police to another state. But because he was subpoenaed, it was clear by the Inspector of Police to go and testify. The subpoena that was served for him was to produce the result in the custody of the Nigerian police, which they had in their custody in Imo State.
Okay, so let me ask you then. Now, why is it that he was the one that was subpoenaed, because if the court wanted certification and proper whatever it is they wanted about those results, why didn't they subpoena INEC, who were the custodians of those particular results? Why?
No, because INEC, when they pleaded that result existed, but it was excluded but that those results were excluded by INEC. And INEC kept quiet over it. So they have to call the police, who also, in election results are always produced in counterpart. Party agents, police officers, and all others, they will have copies of results. They are always produced in counterpart. So because INEC kept quiet and was being evasive over the existence of that result, so they subpoenaed the police, who produced the one they have in their custody. The subpoena that was had for him was not to produce, not to testify, not to give evidence. And the disciplinary bill produced that result before the court and tender it. Right. That point became an issue before the first tribunal. You get my point? And the lower tribunal, and the actual fact, made a ruling on that. That ruling was given by Honorable Justice Idayatu Sule, who was a member of the lower tribunal.
Another thing we would like you to respond to or shed some light on, I mean, seeing the response that has met this particular judgment. I mean, looking at the front page of the dailies, you see protests across states, especially people saying that they don't understand how this played out and they're not accepting it. You probably saw the statement from the People's Democratic Party. So I'd like to ask you, in your experience as a legal practitioner, have you seen this sort of response to a judgment, and what does it tell you about this judgment?
You see, Nigeria is a very interesting country. You see, politicians. I'm also a politician. I'm a lawyer. Politicians come up with various ploys and antics. You get my point? There is nothing stops the new governor, or APC, to come up with their own protest tomorrow. You remember the youth against what do we call it then? Youth against Abacha. The other side will mobilize its people. They'll give them money. These are politically motivated mobs. We are too idle here. Many Nigerians are jobless. So it is not difficult for anybody to mobilize and move people onto the street. If we're
All right, let's get the reaction of the lawyers, your colleague in Abuja as well. Markwe?
Well, thank you, Chamberlain. We'll still have with us Mr. Victor Gewa in our studios. You heard what Mr. Ojo said there.
Yes, let me now quickly go to some issues. The first contention in that judgment is this. And why you are seeing this kind of reaction is that INEC said that INEC did not admit the results as stated by my colleague. They did not. What they said was that in their response was that the results were false. And the court, if you look at the dissenting judgment by Frederick Ohayo, he was saying that when you allege that a result is false, it is incumbent on you to prove, which is when you talk about false, we are talking about forgery. So INEC said, look, this result is false. This result did not emanate from us. And I will tell you the effect of the decision of the Supreme Court. Now, the results were tendered by the DCP and some of the coalition officer of the political party. Now, the affirming of that decision, of those votes being valid, is that when politicians, just like I'm an election observer and I know what I'm talking about, and we have seen this thing in the process, when politicians get to the election period, they go and target the election result. It's the 8A form. They keep it and allow the voting process to go on until about 3 o'clock. They disrupt the process using their talks and every other thing. They go into their various houses and enclaves
to write the result.
Looking at the number of persons who have been accredited. And now they will from what the Supreme Court have done, the politician will now produce the result. This result did not come from INEC. It came from the politician.
But the presiding officer signed the result.
No, the presiding officer, we don't have that. I don't have that facts from the record. There was no statement to the effect that the presiding officer signed, because they only number of presiding officers that gave testimony were 28 out of the 388 polling units. So affirming...
Should all the 388 have been presented?
That is what the decision of the Supreme Court is. That for you to establish the fact that elections were conducted in the various...
The point I'm trying to make is that the 28 could not have stood as a sampling of perhaps what the 388 would have said.
That is the point. That the 28 couldn't have been the result. You can have 20, you could have won in 28 units out of the 388 units.
No,
so
but there is a problem there in the sense that if the presiding officers signed those results,
yes,
and they were set aside at the collation center,
yes,
the question is, what is the process for INEC to be able to nullify results that have already been signed by presiding officers at the polling units?
Yes, I will tell you the position. The first is that why the presiding officer can sign the results. INEC, because presiding officers are ad hoc staff. They have been hijacked. I have participated in an election where the presiding officers were hijacked. Some voluntarily considered to compromise. They were taken to the houses of politicians to sign result sheet, because how did the politician get the result sheet?
But we didn't hear that in this case.
No.
There were
that is what INEC was saying when they said that result was false.
There were instances where presiding officers, I mean, only in the same Imo state,
yes,
there were instances where, you know, collation officers and presiding officers did allege that they were forced to declare certain results. Isn't that right?
That is exactly what we are saying.
But in this instance, the presiding officers who came to court did not say that they were forced or cajoled or bribed or, you know, put under any duress whatsoever to sign those results. Did we hear that?
No, we didn't hear that. At the same time, INEC had a reason for saying that when INEC, the agency, says that those results were false, what it means is that he has cut off himself from every activities as it relates to that said results. That is the presumption. I mean, they are the custodian of the election. They conduct the election.
So why do you think the Supreme Court admitted those results then?
Good. Now, the reason why the Supreme Court admitted the result was this. There is a principle that was established in the case of Agency versus Honorables in 1984, then Sikibo versus Uchendu, that when the contestation is to the exclusion of result, and this is where the issues are. The principle was that when the contestation is to the exclusion of result, the only proof to show that my result was excluded is to produce the result, which is EC8A, and EC8B, which is the collision result. So what they did is that Supreme Court has a principle that was established in 1984, and in the case of Uchendu versus Ikwenga unreported, that if that is the condition, if your case is that certain result was excluded, the only proof you have is to produce the result you allege to have been excluded, which they did by producing those number of EC8A form and EC8B form. So that was, in answering your question, that was what I feel, looking at the precedent, would be the reason why the Supreme Court had
admitted those results.
Well, affirmed the admission of those results. Because the trial court discountenanced the result. The Court of Appeal discountenanced the result. And my problem is that the precedent is
the Court of Appeal, there was a minority judgment.
That was just a single minority judgment.
Yeah, but it was a minority judgment nonetheless.
However, the fact is this, that when there are concurrent facts of the trial court, the Supreme Court couldn't have intervened in disrupting the decision, except when the decision is perverse. And in this case, we have not seen any element of perverse in the decision of the two trial courts that held findings as to facts, both in the trial and in the Court of Appeal. So the second implication of that is this. You have, like I said, the Supreme Court, by that decision, and that is why you are getting this kind of reaction. The Supreme Court has, by that decision, given a judicial support or imprimatur to the fact that what is important to us is not whether elections were conducted in terms of people going to vote, but if I can just know how to get across to INEC personnel, hold one of the results, and wait until all the activities is gone, and present that result, then am I likely to be the candidate of Any election.
That is one reading of it. There's certainly another implication for that. But let's go on this break and we'll come back and finish it off when we return. Please stay with us.
Welcome back to Sunrise Daily, still focusing on reactions concerning the Supreme Court judgment for the Imo governorship elections. Mr. Adebayo Ojo, former Attorney General and the Commissioner for Justice in Oyo State, he joins us via Skype in London. Well, Ms. Ojo, we're already having some reactions concerning your initial submission. Before we'll get you to respond to what your colleague has said in Abuja. First, there are those who believe that they argue that, wait a minute, but the very first part of any pleading is general denial. So if INEC themselves disown those results, saying it didn't emanate from them, how come the Supreme Court then went ahead and relied on those results? Because they say INEC is the only body that can authenticate those results.
No. Let me say this. In pleadings, the cardinal rule of pleading is that general denial is no denial. Specific pleading, once there is specific allegation, it must be denied specifically. And not by being evasive. That's the law. You see, those results were admitted at trial as a PPP1 to PPP 366. Exhibit PPP1 to PPP 366, and they were admitted and marked and marked by the court. And again, let me add, all those results were signed by party agents of all the political parties that participated in that election. Again, all the results, all those exhibits were signed and authenticated by the presiding officers in all the 388 poll units. And finally, the result, the police was supine. You see, when a witness is supine, that witness is not a witness of either of the party. Is a witness of the court, because that witness came to court under the command of the court to come and produce or to give evidence in the matter.
Well, I hear you on that point, but part of what they still don't understand is that, yes, you want to, your subpoena, you did subpoena the police. First of all, they asked, look, why was it the police officer? Was he present in all those polling units? Why didn't you subpoena?
You are familiar with our case. In all our polling units, police officers and other security agencies are always present, compulsively. They are not present, and they also sign, and they are also given copies of all the results at every polling unit.
What about how do you react to what your colleague said in Abuja? That how come, just a minute, how come he didn't certify or speak to all those other polling units? Because he spoke to some of them, but not all of them.
You see, politicians on each side of the fight, this one will allege that I have results.
Okay, we seem to have lost him, but we're going to get him back because he was going to respond. Well, if you can hear me, yes. Okay, go ahead and conclude your thoughts on that matter.
I said, you see, why you say it is normal and it's not strange that when APC alleged or pleaded that result was inexistent, once we expect, especially PDP will deny the existence of that result. So it's beholds on the other on the party. He will assert must prove to
all
call right. Unbiased arbiter, who is the police in the matter, to come and produce those results in their own custody.
So
you see,
do we then expect that having gone through those results, we assume that the court collated those results and then calculated and saw that he had the highest number of votes and then eventually declared him winner. But do we expect that when they perhaps release details of why they did that, are they going to also let us know the results that all the other candidates also got?
Throughout the trial, from the first court to the Supreme Court, PDP or INEC never produced another result. It would have been different if two sets of results were available for the court to look at. But only one set of results produced by the police, and we, the other man, alleged that this result in those 388 units were inexistent. So there was nothing on the other side. Neither INEC nor the PDP or nor its candidate produced a contrary result to what was pleaded by Mr. Hope Usodima.
Very quickly.
So all the results signed.
Okay, let me just quickly ask you this one. You remember that part of that judgment that was delivered, read by Justice Kekereekun, said that the lower courts misconstrued the case of the appellants, that he was challenging the validity of the election as opposed to his real challenge of the unlawful exclusion of votes. Now, the word that stood out for me there is the fact that the lower courts were said to have misconstrued what the appellant was asking. How does that strike you in jurisprudence?
Yes, very correct, sir. The case of Mr. Usodima, pure and simple before the lower tribunal, was that my result in 388 units admitted by the tribunal as PPP1 to PPP3 6s were excluded and were not counted in the factual result that was declared by INEC, that they were excluded.
My question, Mr. Ojo, is that this happened from the two lower courts, the tribunal and the appeal court. Both cases, both courts misconstrued the pleading of the appellants. That's what's basically causing all this confusion, don't you think?
No, there's no confusion. You see, people should not make mistake. Judges are human beings. And court can also add and make mistake. There's nothing new in that. You see, but one thing must be present there. The mistake must be the mistake of what we call mistake of the head and not that of the heart. Because if it is mistake of the heart, then that means the judgment has been compromised. A judge is bound to make mistake. So, and it is not new. My colleague, Governor Nyesom Wike of Rivers State, lost at the first tribunal. He lost at the court of appeal. He won in the Supreme Court. Everything did not fall. Have you forgotten? He lost at the court of appeal. He lost at the High Court. He lost at the court of appeal in a unanimous judgment.
But you know, if I can extend this conversation a little bit, Mr. Ojo, you would know that many people have also been saying that, look, why do all cases have to get as far as the Supreme Court? So if the two lower courts could misconstrue the contestation of the appellants, it means that everyone is saying that all cases must, no matter how trivial the case is, all cases must still get to the Supreme Court before you get judgment. That's what this is sounding like.
When we started this nascent democracy of ours in 1999, all election petitions were of two levels. The governorship, the National Assembly, the State Assembly were of two levels, first tribunal and ended at the Court of Appeal. The presidential also used to be of two levels, from the first court, which is the Court of Appeal in their own instance, and then the Supreme Court. But later, the National Assembly, in their own wisdom, and so freely reside the National Assembly, because they represent all of us. They amended, because I said, no, let the governorship election come up as far as to the Supreme Court, which is the apex court. Well, I have no problem with that. And we've seen justice being done in certain cases with respect to that. And I've cited, as an example, the case of Governor Nyesom Wike. Because if the matter had not gone up to the Supreme Court, Governor Wike wouldn't have been governor by now. Because he lost at the first tribunal, lost at the Court of Appeal. But he succeeded in the Supreme Court. Because the Supreme Court being the apex court in this country and the final court.
Okay, we'll let you explain some other matters, clarification that lots of people are equally confused about. But let's get to Abuja as well and get the response from your colleague there, Mark.
Thank you, Chimling. We still have with us Mr. Victor Gewa. You're painting a scenario before we went on break. I'm sure there are issues you want to respond to, but let's quickly finish with this scenario you're painting about politicians getting desperate and disrupting elections and, you know, seizing the results and writing them in their homes. That's one scenario, but there's another scenario where, you know, in the strongholds of certain politicians, there could be an attempt to disrupt and ensure that no elections take place there, or that, you know, because of violence, those elections are declared invalid by INEC. And, you know, some people will say that that could be another tactic. So do you see there the Supreme Court trying to cure some sort of, will I say, or trying to cure the desperation of politicians, whichever way the pendulum swings?
Yes, that could have been an attempt to solve that mischief. If the contestation is that elections, if the position of INEC is that elections were conducted, but it was disrupted by violence and other issues, but not when the candidate is saying, no, because the candidate did not allege violence. Mm-hmm. The candidate did not allege manipulation.
Yeah, but INEC
so the presumption is that what he's saying is that, look, election went all very well to such an extent that we have a result.
Exactly.
But this result was excluded.
So the issue here is this. On what grounds was INEC saying these are not our results?
Good.
If their presiding officers are saying, yes, indeed, we signed some of these results.
The basis, I'm not INEC. The basic, the foundation upon which INEC said they never conducted the election was because they claimed that there was violence. That was why there was no result. That they did not even conduct. INEC, what he was saying was that when you allege false results, when you have issue of overvoting, rigging, manipulation of result, it is in that case you can produce the actual result and the result of overvoting. And in that situation, you present to the court the two results and lead evidence to show which of the results is the valid result. That is not the case in Uzodima's matter. Uzodima was not saying that, look, yes, there was election, there was violence, but at the end of that exercise, I won. Uzodima said from his position, there was an election that was conducted and concluded, and I have the result.
No, the point
and INEC is saying,
yes,
no, we did not conduct election in that area, such that your result you are presenting to us is false. Do you get the point? So now, when INEC is supposed to have cancelled the result, is when cancel the result and order. The proper thing to do, like we were saying, is that because the result claimed by Uzodima is 213,657 votes, which is enough to upturn
the election.
So the proper thing for INEC to have done is to order a rerun under the marginal of lead principle.
Yes.
Did you get it?
But they didn't do that.
But they didn't do that.
Yes.
But again, the other mistake is this. The Supreme Court, in my own view, couldn't have calculated the results for INEC.
Why not?
For two reasons. Now, the court under the law, in the case of Odun versus Udensi, have said that the court has the power
to do so,
to collect results.
Yeah.
On two grounds. One, when there is claim of wrongful collation. And two, where you claim that your results were added from a non-existent vote. The difference is
what does non-existent vote mean?
You claim that somebody has inflated, that's the word they use, to wrongful calculation and inflation from a non-existent vote. These are the two conditions the Supreme Court have established upon which court can collate results. Because ordinarily, it is not the duty of the court to conduct elections. So the only time the court can invoke that power to collate results is when the person is claiming that there is wrongful calculation. In that case, it is arithmetical. There's an arithmetical error. Two is when there is an inflation from a non-existent vote. That is criminal. Now, there are two different things. In the wrongful calculation, it could be a mistake from the presiding officers. They are all human beings. But when they're talking about inflation of results in the language of the court from a non-existent vote, it is criminal. Yeah, but because it is deliberate. So that is only the reason where the court can collate results. So the Supreme Court in this case collated the results when The issue was not inflation from votes that were not existing.
Yeah, but that is your own reading of it, because some people
No,
will
that
say...
is the law.
That's what I'm saying. This is your reading of the law. The law is there, and there's the reading of the law. There's the interpretation of the law. So, and the Supreme Court is the one vested with the powers, the ultimate powers, to interpret the law. If they have said wrongful calculation also includes, you know, addition of votes that were not added, isn't it up to them if they found that the votes were valid?
Well, I don't think that the Supreme Court at that level could have taken the decision to determine whether a vote is valid when the power to establish whether or not a vote is valid is that of INEC.
So do we blame INEC here? Because if we agree that 388 polling units were excluded and INEC did not produce results, and these people, it would seem, were disenfranchised. I mean, there are huge questions to be asked as to why INEC did not declare inconclusive elections.
Correct, I agree with you.
In that situation.
Yeah, the INEC instigated this crisis. Because what would the proper thing to have done is to have declared that result inconclusive, because the difference in the number of registered voters in that particular 388 unit would have been enough to upturn the result, like what we have just seen, as alleged by Hope Uzodinma, who claimed, and you see the other thing is that he claimed that he scored 213,667 votes. And INEC is saying that, my brother, we didn't even conduct elections, were not conducted there. You see, it is a bit dicey. It is, like I said, the only condition known to law, established by the same court.
Yeah, but the INEC bring its own witnesses to prove that elections were not conducted there. Isn't that another question?
Wow, yeah, that is that question. I think INEC brought, to the best of my knowledge, 5 witnesses. I stand to be corrected. But whether they were able to prove, and that is one of the decisions of the dissenting judge in the Court of Appeal, Justice Frederick Uwayo. He said that when INEC, what he said was INEC did not prove the case of false result or forgery. Because when INEC is saying, the implication is that when you say this result is false, what you are saying that the result have been forged. Now, there are two different things. The INEC election material, the EC8A, belongs to INEC. So INEC might not be denying that form
itself.
But INEC is denying the results imputed in that form. So INEC ordinarily will tell you, this is my form because it came from me. And INEC can authenticate it. But INEC is saying the results that you ascribe to this form. I don't know.
The question is, INEC needs to go beyond just saying, I don't know anything about this number, to actually show that indeed they did not conduct elections there, or that the results, you know, just flew to that sheet somehow miraculously.
But INEC is denying it. It's Hope Uzodinma that is asserting. It's he that asserts that must prove. And the other part is that he is asserting that I have a result. This is the result. INEC is saying.
I want you to quickly speak to those who are now saying that the Supreme Court should reverse itself. Is that a possibility?
Yes, there is. There are conditions upon which it's very rare, but it is possible.
Do you see it happening? Is this one of the conditions upon which it can happen?
Wow, it's a bit dicey. It's dicey because, first of all, it was a unanimous decision, and but it is something the Supreme Court can do because the Supreme Court has done it. And the conditions are: one, when the Supreme Court feels that as at the time it took its decision, that there were certain facts or certain law it did not take into consideration, the Supreme Court can revert itself and say, oh, this is my position, and we have precedent on that.
But you're not saying it in this scenario.
Well, I think that is really... But I think for the purpose of... Especially...
You're not answering the question. You're not saying it in this scenario.
The Supreme Court should do that. I really feel that the Supreme Court should take a second look, and because of the effect of its decision.
Well, let's quickly go back to Lagos. We have to thank you so much for sharing your thoughts with us this morning. Mr. Victor Giwa is a legal practitioner. Well, let's quickly flip back to Lagos now. Chamberlain.
Yes, indeed. Thank you, Mark. So, Mr. Ojo, let's get you back on this one. First of all, could you respond to this? He highlighted, do you think that the circumstances under which the Supreme Court, who stood as trial court in this case, many question why that happened, those circumstances under which they could have collated the results and then announced it, did they exist in that case?
Yes. Supreme Court did not act as trial court in that matter. Supreme Court acted as the appellate court, the final appellate court in the country, with the court is in the case of Usodima and Eodia.
The one hand.
Hello?
So secondly,
Yes.
did the circumstances under which they could collate the result exist?
Yeah, they existed. And let us get the point clear.
What were they?
So,
Name them. Could you tell us?
Yes, let's get the point clear. I have said it earlier on. The new governor pleaded that his result in 388 units were excluded and that they were not counted or added up by INEC in the final result that was declared. And that those results were admitted by the court, the first court, the lower tribunal, as exhibit PPP1 to PPP 366. Whereas INEC and PDP, on the other hand, they didn't join issue with him. In respect of that very material pleading. They were, like I said, they were effective. They were not, they didn't make that plaintiff frontally. And all these results were produced before the court. And so we can look at that. And like I said, all the results in those 300 units were signed by all parties, all the party agents of all the political parties that participated in that election.
All right, Mr. Joe, let me ask you this.
Yes.
Are you aware, I don't know how much of the following you did about how the thing went from tribunal up until the Supreme Court, but while it went on, are you aware that Hopos Odoma stood as PW11 at the tribunal? And word was that he couldn't read the results that were on those papers. And secondly, hang on. And secondly, they also say that the polling agents themselves, those who came to testify, couldn't read what was written on those forms, those results, except the scores of the APC.
No, let me say this. PW11 in that case, PW11 was DCP Rabiu and not Mr. Osodima, the DCP that was subpoenaed. You see, election results were always produced in counterpart. The original, with the topmost copy, are always with INEC. The other counterpart for all the parties, or for all the political parties, agents, and the last one will be for the police. Look at my point. So the man in his pleading specifically itemized all the results in each of those 388 units and stated the respective scores of all the political parties. He was very emphatic and very clear. He was very emphatic and very clear.
In addition to that, I hope you can hear me though. In addition to that, some of the issues that it wasn't clear to a lot of people is that if the court had ruled that Uche Nwosu was the candidate of the APC, at what point did Hopos Odoma then become the candidate of the APC?
No, the Supreme Court said, you see, Uche Nwosu appeal was withdrawn at the Supreme Court by its counsel. It was withdrawn in view of the earlier decision of the court, of the Supreme Court, because that suit has become academic.
So just a quick one. Does that then mean that if he had not withdrawn, he would have been the person that would have been declared governor?
And that would be speculative. Because
I'm sorry, I didn't hear that.
Supreme Court, in his case, decided that you cannot claim to be candidate of AA and also APC at the same time, because he was ambivalent. You can't stand as candidate for two political parties. So that was the other decision, and that decision had overreached his petition before the court, and his counsel, acting in the best interest of the bar, withdrew the appeal, and it was dismissed.
Well, what do you think about the question of total number of votes cast in terms of how they tally or how people think that, look, with all of those calculations, it just doesn't tally.
Of the judgment of the Supreme Court, read it and digest it very well. You will see that people are just crying wolf where there's none. You know, politicians, they can demonize anything. And I'm able to say that the judge of the Supreme Court that delivered that lead judgment, Honorable Justice Kudra Kekereekun, is one of the most upright judges we have in this country today. Cerebral, brilliant, and his integrity is second to none. And nobody can fault our integrity. Nobody. In fact, all of us, all lawyers are unanimous that Justice Kekereekun is an integrity.
All right, we have to go. We appreciate you talking to us this morning, Mr. Adebayo, former Attorney General and Commissioner for Justice in Oyo State. We're back in a moment. Stay with us.